everyone, and welcome to Uncivil Law, where we learn through the misfortunes of others. As always, I hope you'll enjoy this legal education content, and today will be the day I earn that subscription. For today's stream, we are doing the first hearing relating to the Gabby, Petito, Brian Lawford lawsuit. This is a lawsuit actually technically between the parents, of course, which is part of the problem, and they have a motion hearing today. This hearing is already in progress. We're about an hour behind. Peter Tragos from Lawyer You Know, looking really sharp there, by the way, on the internet's looking really good in his collaboration. So we're going to pick this up at the beginning of the hearing so we don't miss anything. This is not, I suppose, live in that sense because we're about an hour behind, but we're going to listen to it. If there are breaks or something, we'll catch up along the way. So let's go ahead and get started with all this.
Things that were in the motions, and then the judge will likely reserve ruling. He doesn't have to. Within his discretion, he can make a call right now and say granted or denied with or without prejudice. He can make that call right now. But most people expect that he's going to reserve ruling, and then we'll find out later in a written order what his decision is and why his decision came down.
The correct decision is to dismiss.
I would be willing to guess that this judge has already reviewed all the materials. He's going to listen to the oral arguments, and then he'll make his decision later. And it looks like the judge has just entered the courtroom. That's our cue.
Let's listen in.
The correct decision is
to
dismiss. We'll be back
here with you live, folks, after the hearing is concluded.
And good afternoon. I am electronically present in the courtroom today as I'm abiding by the court's quarantine protocols. We have technology in place to allow the court's work to continue.
That makes no sense.
My preparation for all hearings today, not simply these two cases, has been the same. The court is prepared. Whether you are joining us in person in the courtroom or via Zoom, welcome. There are two housekeeping items to address. First, only credentialed media authorized by the court's public information officer, as well as the court reporter, may record these proceedings in the courtroom or on Zoom. If you have not received that authorization in advance, you may not record these proceedings. Second, we have two cases this afternoon. The first case we will address involves the parents as parties in the lawsuit. We will complete that hearing before moving on to the second case, which is the case involving the estates. So let's begin.
The estate might have some legs, it just doesn't matter.
Joseph Petito and Nicole Schmidt versus Christopher Laundrie and Roberta Laundrie, case number 2022 CA 11.
Yeah, you can sue the estate, it just doesn't matter. There's no assets.
Please make their appearances and introduce their clients if they're present.
Good afternoon, Your Honor. Patrick Riley Ford, sitting to my right, Joseph Petito, and also sitting to my right, Nicole Schmidt.
Thank you. Mr. Luca.
Good afternoon, Your Honor. Matt Luca on behalf of the defendants, Christopher and Roberta Laundrie, who are not present.
Thank you very much.
Laundries aren't present. No reason for them to be.
The motion to dismiss filed by the Laundries, which is at document identification number or DIN 33. The plaintiffs have filed a response, which is at DIN 38. And the defendants have filed a reply, which is at DIN 39. I've reviewed those filings as well as the other materials submitted by the parties. So, Mr. Luca, you have the floor, and if you'd like to go to the lectern, that would be great.
Yes, thank you, Your Honor.
The only words you really need to say is no affirmative duty. That's how I'd start this motion to dismiss orally. I just started by saying no affirmative duty. This is the guiding principle that is the basis of our motion to dismiss. And just start with that.
What do they tell actors, Your Honor? Just find a place on the wall and stare at that. Well, thank you, Your Honor, for your time this afternoon. I appreciate it. Your Honor, I won't spend any time going through the general standard on a motion to dismiss. I know Your Honor is well aware of that. So I'll just jump right in. Your Honor, our position is straightforward. A cause of action for intentional infliction of emotional distress was not intended to include liability for a defendant who does nothing.
No affirmative duty are the magic words.
All of our arguments regarding outrageousness, legally permissible conduct, causation, and the presence of the plaintiff all go back to that premise and show why there is no legal footing for this cause of action in this context. Conduct that amounts to remaining silent and maintaining privacy is not intentional infliction of emotional distress.
Yep.
And there are no cases where such conduct was found to be intentional infliction of emotional distress.
Yep.
Rather, plaintiffs argue that the Laundries had an obligation, a duty to speak.
Nope.
The law imposes no such obligation to speak.
No affirmative
And the
duty.
state and federal constitutions support that. In our society, under our laws, people are free not to speak.
That too.
Your Honor, the elements of the cause of action alleged are a deliberate or reckless infliction of mental suffering, outrageous conduct, the conduct caused the emotional distress, and the distress was severe. I'll first address the outrageous conduct element, Your Honor. So the standard for determining whether or not conduct is outrageous is,
Well, first of all, there has to be a thing that
the
happens.
behavior claimed to
That would be
constitute
good.
the intentional
For there to be
infliction of
outrageous
emotional
conduct,
distress
first there
must
needs to be
so
conduct,
outrageous in
which means a
character
thing needs to
and
occur.
so extreme
It's a good
in
place to
degree
start.
as to go beyond all possible bounds of decency. That is conduct that is atrocious and utterly intolerable in a civilized society. It is an objective standard, and the subjective response of the plaintiffs is not what controls. The issue of whether or not conduct is outrageous is a question of law and for the court to decide. And that standard is extremely high in Florida.
Also that. Intentional infliction of emotional
It is
distress
not
is
enough that
basically
the defendant
borderline
acted with
impossible
an intent,
everywhere.
which is tortious or even criminal, or that the defendant intended to inflict emotional distress, or even that the defendant's conduct can be
Air
characterized
Starry
by
Music
malice
says they are
or
as
a
shady as they
degree of
come.
aggravation
They may be as
which
shady
would
as they come.
entitle
I'm
the
not arguing
plaintiff
whether
to
they are or
punitive
are not
damages
shady. There's just
for another tort.
there's no basis in law for this lawsuit.
Now, Your Honor,
If you want to say they're
looking at the
shady, that's
amended
fine. There's just no
complaint
basis in law for this.
case, Paragraph 32 provides a summary of what the plaintiffs alleged is the conduct that was outrageous. So they allege first, failing to advise the plaintiffs that Ms. Petito was deceased.
That's
Second,
yep.
failing to disclose to the plaintiffs the location of Ms. Petito's
That's a
body.
non-starter.
Third, taking a family vacation with their son,
Non-starter.
Brian Laundrie, who they alleged had murdered Ms. Petito while the plaintiffs were looking for Ms. Petito. Fourth, blocking access to their cell phone
Non-starter.
and Facebook page to preclude the plaintiffs from contacting them and getting information regarding Ms. Petito. And finally, that the Laundrie's attorney, not the Laundries themselves, issued a statement to the press expressing hope that the search for Ms. Petito is successful and that Ms. Petito is
Not
reunited
outrageous.
with her family.
Is there a distinction between the attorney doing it on behalf of the Laundries versus the Laundries?
Well, Your Honor, the attorney is obviously not a defendant in this case, and there are no allegations that within the complaint that the Laundries directed the attorney to make that statement, what information the attorney had with regard to making that statement.
Yep, it's basically just
So
Walterman all over
I do
again.
believe that there is a distinction, Your Honor.
Isn't under Florida law, isn't the attorney the agent of the client?
I do agree with that, Your Honor.
Then why does it matter that the attorney and not the Laundries themselves made the statement?
Well, Your Honor, what we don't know.
The statement's
what is
not
alleged
outrageous.
in the complaint is whether
You hope
their
they're
attorney
found.
was
That's not an
making
outrageous
that
statement.
on behalf of the Laundries or whether he was making that statement in his personal capacity.
Well, on a motion to dismiss, how am I supposed to construe the well-pled allegations?
Your Honor, on a motion to dismiss, I would argue to the court.
Is there a way to
that
boost the volume a
by
bit?
not
I guess there is. Just getting the
alleging in
volume level is
complaint
always
that the attorney
borderline
was the
impossible
agent
because there's no
of the
equalization. I
plaintiff-
can't
I'm sorry, of the
see
defendants for
visually where the
purposes of
volume
making
level
that
is.
statement that they have that the plaintiffs have not
Hopefully that's right.
alleged sufficient conduct that
Fucking
would,
hate
that would,
StreamYards.
cause liability for the
Audio management
defendants
sucks.
for the statement by their attorney.
Well, assume for the sake of argument, the court concludes that there was sufficient allegations that the attorney is the agent.
He's
for
an
the
agent.
Laundries.
Fine. It's
Assume
just the
that-
statement's not outrageous. The Laundries themselves could have said
Now
it. It
we
doesn't
have a
matter.
situation where the Laundries themselves are making a statement and not standing silent. So what? does
The
that
statement
change
is
to
not
the
outrageous.
Arguing about staying silent.
Your Honor, I still don't.
If saying
think
I
it
hope that you're
necessarily
able to
makes a
find them
difference.
counts as an
I mean,
outrageous
I
statement,
understand what the court's saying.
give me a
that,
break.
That if we impute that statement to the defendants, that would not be complete silence by them. However, the defendants do have a constitutional right to have an attorney and to have that attorney speak. So again, Your Honor, in my view, the attorney was merely exercising.
This
the
is a hearing
constitutional
because we're on
rights
a
of both
motion to
the attorney
dismiss.
and of his
It's
client
a question of law.
by making a statement.
So all we need is a judge.
Okay, but when you make it.
Do I have volume controller extension for your browser? No, I'm not sure it would help either way.
Silent, right?
I would agree with that, Your Honor. Yes.
You may continue.
Thank you.
It would just tell me how much to, it wouldn't give me the right, it wouldn't
Your
show
Honor,
me
the,
visually where the volume level is.
The plaintiff's claim of outrageous conduct in this context is novel. The plaintiffs have cited no cases where a person's silence except with regard to what Your Honor just raised with regard to their attorney's statement, was considered outrageous, regardless of the circumstances. And they certainly haven't cited any cases where a statement by a
I think this
person's
will be
attorney
dismissed. I think
has
this
been
lawsuit is
considered
really, really dumb.
outrageous.
I think this
All of
lawsuit
the
is
cases they've
incredibly
cited
dumb.
involves some action by the defendant. Accepting the allegations of the amended complaint is true and allowing the case to proceed further would require any person and their family to speak about an alleged crime or other tragic event of which they may or may not possess knowledge. And that is simply not
No
something
affirmative
that
duty.
our legal system requires.
Also, what is up with your hand movement?
For example, if a family member came to me and told me that they did
The
something
fact the judge is there
terrible,
physically is
the plaintiffs
bizarre.
want the law to impose an obligation on me to then report
Petito's parents are
what that
suing
family
Laundrie's
member
parents.
told me.
That's who this
And that
lawsuit
just
is
isn't the
about.
law.
Petito's parents are suing Laundrie's parents.
Even if that
Well,
I'm sorry, go
Let
ahead.
me
Your
make sure I understand what you're saying. Are you saying that they came to you in your capacity as a lawyer or as just a normal person?
Just a normal person, Your Honor, just a family member.
Okay, well, does Florida recognize a privilege, a parent-child privilege?
Your Honor, I'm not arguing privilege. This could be somebody who is not a parent, a child, a wife, a husband, just anybody. My argument is not that there was a privilege.
This is
between
Laundrie's lawyer speaking.
Brian Laundrie and his parents.
Because Laundrie's the one
My
making the motion to
argument
dismiss.
is that
So they go first.
even if Brian Laundrie conveyed information to his parents, that they don't have a requirement then to speak.
Why after this get a
regard
hearing?
to that
Because what's the
information. They
alternative?
don't have to share it.
Okay,
I mean,
well,
you have to have a
let's-
hearing on the
let's
motion
go
to
down that
dismiss.
road for a moment, because this is where I'm having some difficulty. I fully understand and get the constitutional right to remain silent.
Do you?
That being said, we're on a motion to dismiss on a complaint where I have to assume the facts are true.
Yes, you can assume all the facts are
And
true. You're just there as a
trying to
matter of
get me
law.
to say that the
He's an agent,
complaint
sure.
itself
They made the statements on his
demonstrates the
behalf. Sure, you can
existence
assume all that.
of,
Just doesn't get you anywhere.
right to remain silent. And I'm trying to understand how that is, or is that more of an affirmative?
How is the
defense
court's
that should be
COVID
fleshed
guidelines
out?
keeping him out of the same courtroom
Your
as
Honor,
everyone
I
else?
don't-
How's that a
I don't agree
thing?
that it's an
How does that
affirmative
make any
defense that
sense?
needs to be fleshed out. I believe the court can.
On what grounds are they trying to sue? Intentional infliction of
you know,
emotional
obviously,
distress,
the complaint alleges that
which makes no
the
sense.
defendants were residents of the state of Florida, so the Constitution of Florida and the Constitution of the United States apply to them. And
No
if you look at the
affirmative
complaint,
duty.
Your Honor, even though it doesn't allege a formal criminal investigation, it doesn't use those magic words, so to speak. It does allege that Brian Laundrie murdered Miss Petito. It alleges that Brian Laundrie engaged in conduct to try to
You can sue Brian
cover
Laundrie
that
for all
up
the
by
good it will
sending
do
text
you.
messages and things like that.
Apparently, this
It
judge is hearing
alleges
both
that
cases.
The defendant,
He's suing. He's
his
hearing the
parents,
case, suing the parents, and
the
also suing
Laundries,
Brian Laundrie.
Were
The
trying
lawsuit against
to,
Brian Laundrie
help
can
him
continue for all
escape
the good it
country.
does.
It alleges that
If I'm the estate, I
Laundrie
just
family
concede
hired
judgment
an
and call it a
attorney.
day. He has no
And
assets. What's
then
the point?
Once they hired the attorney, at that point, all the contact with the plaintiff stopped. And the only statement we have is that one statement by their attorney that the court referenced. So under those circumstances, as alleged in the complaint, Your Honor,
Can't hereby.
that's enough for the court to
I don't
say
know what you want from
somebody
me.
in
What do
that
you want me to do?
situation
I mean, the audio. You want me to
could
jack it up
invoke their
more?
Fifth Amendment privilege.
You want me to jack it up less? You
That's
don't want me to
not-
talk
that's not
over it? I
something
mean,
that
what the
court would
fuck?
Need to find additional facts. The court does not need to look outside the four corners of the complaint. There are sufficient allegations within the complaint that would trigger somebody in that situation exercising their Fifth Amendment privilege. Your Honor, would you prefer for me to continue with the outrageous element or move on to the legally permissible element, since that seems to be
No affirmative duty is the way you had to start this.
Whichever way you want to go.
Okay.
I
Thank you,
mean,
Your Honor.
this attorney's not
I understand.
bad, really, but no affirmative
Your
duty is
Honor,
the way to start
the plaintiff's
this.
cause of
You just
action
go up
could
there and you just
also
literally start it
extend
with
to
Your Honor.
somebody who,
No affirmative
you know,
duty.
may not be in the
These three
situation
words
where
are
they,
the simple
were told
core
something, but
of our
maybe they
motion to
witnessed
dismiss.
something,
No
or
affirmative
maybe they
duty.
came upon some
The
evidence,
parents of
or-
Brian Laundrie had
and
no
somehow-
duty
or somehow they
to the
had
parents
some
of Gabby
information
Petito.
that might be relevant to
They
some
had no
tragic
legal
event.
duty to share any
Um,
information they knew.
The
They
plaintiff's
had no
cause
legal
of
duty
action would impose an
to
obligation on
make
people
their
like
phone
that
available
to contact
or
the
to allow them to be
families who may
contacted
be involved
or
in that
to make a
situation
statement.
and disclose what they knew, or they would
I mean,
fear
that's
being
where you got to
sued.
start this.
The slippery slope of allowing this cause of action to proceed would really require anyone with knowledge of events that are hurtful or which cause emotional distress to another to convey their knowledge or potentially be exposed to liability. Now, the underlying crime.
But again, I go back to, there's an allegation that the Laundries made an affirmative statement.
Thunderlove says the proper answer is
and
tell
put
people to
out
get
the
bent.
public
Probably.
various statements. So am I not supposed to consider that conduct? Because that's a voluntary act by the Laundries.
I understand, Your Honor, and I assume you're referring to the one statement by the attorney alleged in the complaint. Assuming for the sake of argument that is an affirmative.
The Petito parents
statement by
showed
the
up
Laundries,
so that they can be sympathetic
Your
and
Honor,
cry.
you can definitely consider that. But again, in the context of the overall case, is that
Don't troll me,
statement
Jacob.
alone sufficient to meet the standard for outrageousness? If, let's say, for example, I had some knowledge about a crime that somebody committed, and I made a public statement about some aspect of that case, but I didn't share everything that I knew, or I hedged my bet, so to speak. Would I then be subject to liability because I shared something, but I didn't share other things? That's really the question, Your Honor. Is what are we going to require of people in a situation
No affirmative
like this?
duty.
Are we
It's
gonna
not
require
any more
them to say
complicated than this.
everything
I can't
that
believe
they
you've been
know?
talking this long,
Or are they
and the
gonna be
phrase "no
allowed
affirmative duty"
to
hasn't
speak freely
exited
or
your
not
lips.
speak at all? That's really the question before Your Honor. And Your Honor, I think it's important to keep in mind the standard that we're talking about here. That the conduct has to be atrocious and utterly intolerable in a civilized society. People who are faced with difficult challenges have to make difficult choices. In our society, which I would propose is civilized, recognizes at its core that things like remaining silent or speaking through an attorney are foundational rights.
Or more importantly, just not doing things.
And those are choices that our society
The more
considers
fundamental right here is the
entirely
right to
tolerable.
not do things.
And in fact, they're codified in our founding documents. So, Your Honor, even considering the statement by the attorney, I would submit to Your Honor that
What does no affirmative
that's not
duty mean?
atrocious, it's
No
not
affirmative duty means
intolerable in a
exactly what it
civilized
sounds. A
society
duty is an
for their
obligation.
attorney to make a statement
A
of
duty
that
is
way.
something you must. A duty is
Your Honor, another
something
thing I'd
you
like to
are
address that the plaintiffs
required.
raised in
Something
their
that's required of
response
you.
is that
An affirmative duty is something that
that
you
the Laundries
actively
were
must
somehow
do,
in an
as opposed to a
unequal
negative
position
duty, incidentally,
to,
which is where you have to
to the
refrain from doing
plaintiffs, and
something.
that made their
So a
conduct
negative duty would be a
particularly
duty to
outrageous.
not do things.
Your Honor, I don't
An affirmative
think
duty
that,
is a duty to do
the
things.
standard for unequal
No affirmative
positions
duty
is
just
really
means
what
that
the
people have
plaintiffs,
no obligation to do stuff.
the plaintiffs would
That's what it
qualify that
means.
under this circumstance. Your Honor, in Dependable Life Insurance
Mocking the
Company
Petito family
versus
is making me
Harris,
walk away from here.
which is a 5th DCA case
Bye.
in 1987. It's cited in our papers. Your Honor, in that case, and what the plaintiffs rely upon is restatement of tort section 46, subsection E, which states this unequal position argument. And what the restatement says
What was
is
it that the other chatter said?
extreme
Get
and
bent?
outrageous character of the conduct may arise from an abuse by the actor of a position or a relation with another which gives him actual or apparent authority.
And
over
I
the
take
other,
nothing back. They're
or the
obviously
power
here
to
in the
affect his
courtroom
interests.
in order to
Thus, an
cry
attempt
and
extort money by a
to
threat
gain
of
emotional
arrest
sympathy. That's
may
the
make
reason they're
the actor
physically here.
liable even
They're
where the
here to
arrest
show their
or the
face
threat
in
alone
order to
would
look
not do so.
sad and be
In
sad and
particular,
show them
police
face
officers,
to
school
show
authorities,
sympathy. They're
landlords,
here
and
as an
collecting
emotional
creditors
emotional
have been held
manipulation.
liable for
There's no
extreme
other reason
abuse
for them to
of
be
their
here. That's the
position.
reason they're here.
Even in such cases,
That's not
however, the
mocking, that's just
annoyances
observing
that are
why they're
not
here.
Extreme. I'm sorry.
Look at her.
Even in such cases,
She's rubbing
however,
her
the
cross
actor
with her
has
eyes
not been
closed
held liable for
and
mere
wiping her
insults,
eyes. She might be
indignities, or
genuinely feeling
annoyances
those things,
that are not
but the reason
extreme
she's
or
here is to feel
outrageous.
those things.
So,
She
Your
is
Honor,
here
in Harris,
to draw sympathy and empathy.
what the court recognized there is that the results
This
of this
is not a legal
unequal
argument.
position must be something that is akin to extortion, meaning that somebody threatens another person based upon their position to cause some harm. Like, you know, I'm gonna cause you to lose your job. I'm gonna cause you to be arrested. I'm gonna hurt
Also,
your family.
quit repeating
something
statements
like
5 and
that.
6 times.
That's really what it's about.
Thank
It's
you for
about
playing.
somebody who
Goodbye.
has some authority to affect the person's life. It's not a situation where somebody might have information that another person doesn't have and they simply don't share it.
You need more volume?
That's not really
I can
what
turn up some more.
what the Harris case or what the restatement are talking about when they say unequal positions. Now, Your Honor, moving on to the assertion of illegal rights. The standard with regard to that element is that the conduct, although it would otherwise be extreme, such insistence is certain to cause emotional distress. Now, we have several rights at play here, Your Honor. You brought up one earlier, the Fifth Amendment right to remain silent. That is certainly one of them. There's also the First Amendment right of freedom of thought, which would include both the right to speak freely and the right to not speak at all. And that was cited in Woolley versus Maynard, a Supreme Court case from 1977. Again, it's in our papers.
For what it's worth, by the way,
Aren't
one of the
we
reasons I repeat
responsible
things
for the
5 and
words
6
that we
times
say
is
when
because
we
I know
say
from
them?
past experience
I would agree with
that
that,
if I
Your
only
Honor,
say it
certainly.
1 or 2 or
Certainly,
3
if you say
times,
word-
people don't hear it. People
Johnny,
still don't
that
hear it if I
just
say it
got
5 or 6
Found
times,
civilly
but at least I'm
liable
trying.
for defamation by what his attorney said, right?
Again, Your Honor, I understand that in certain contexts, the statements of an attorney could potentially be, lead to something like defamation. I agree with you on that. I think really what
Look
we're
at her.
what we're
She's still
talking
rubbing
about
that
here,
cross.
though, Your Honor, is a statement by an attorney that even in and of itself is certainly not defamation, and it is not outrageous.
My understanding of the statement, and correct me if I'm wrong, is the Laundries knew, and again, this is on a motion to dismiss, so I have to accept what is alleged as true. Not that
You
it
can
is
accept
true,
all
but I
those things
have
are
to
true.
accept it as true.
That is
the
also, he's
Laundries
making a slight
knew
mistake here by
where
fighting the
the,
hypothetical.
Gabby's body was.
He's making a slight mistake by
And they put out a
fighting the
statement in
hypothetical because he
middle of
doesn't
the
need to.
search,
He doesn't need to
hoping
change the
about
facts. He can steer
the
straight into
success
the
of that
facts.
search, and then
And
not
just be like, yeah, assuming arguendo, all those
either
things, I still
directing
win.
them
That's the whole
or
point.
either staying silent.
So he's making a
And
slight
that's
mistake
kind of my
here.
understanding of what is being alleged. Is that correct, or am I misunderstanding?
No, I believe that's my understanding as well, Your Honor, that the attorney made the statement while the search was ongoing.
And knowing exactly where the Gabby's body was.
Well, Your Honor, again, that's the rub, is the plaintiffs haven't alleged anything in the complaint as to what the attorney's knowledge was when he made that statement, that he had that information. That's a totally different thing. They've alleged that the parents, the defendants, had that information, but they don't allege that information was ever shared with the attorney, or that the attorney had that information when he made that statement. That's kind of the issue, is they haven't really made any allegations about the attorney and what he may or may not have known. It's really all about what the parents knew, and they don't make any allegations about what the parents communicated to the attorney. So really, the attorney's statement, again, if just looking at it,
Do they not have dismissed it before he even got to court? I don't even know what that means.
there really isn't enough.
How do you
there
dismiss
to
something
say
before it
that
gets to
whether or not
court?
when the attorney made that statement, what his knowledge was about any of the facts of the case, frankly.
Uncivil, you need to
And
shame
I
the
would
chat
also
just because
submit to
chat is
you, Your
chat.
Honor, that statement's fairly benign. I mean,
Sounds
I
good.
understand in the context that they've alleged it could be construed as trying to divert attention or something like that. But again, it's a fairly benign statement. I mean, he's really just expressing that he hopes that she returns. And again, they haven't alleged.
Kick them out of the
what
courthouse when they
information
try to
had
file
when he
it.
made that
You
statement.
mean the clerks?
Isn't the
The clerks just
context
file things.
really what's important?
I understand
And that's
what you're
the
asking
second
for.
DCA said in that
Someone has to read
insurance
it.
case where the adjuster denied coverage and did so knowing that the person didn't have long to live and just wanted to outlive the person. And the second, which is binding on me, found that to be outrageous conduct.
That is true, though, Your Honor. In that case, the second DCA said that the actions of the insurance company in simply denying the claim, even though they had
Forego
been
oral
ordered
argument
by
to
a
do it on
judge of
paper?
compensation claims
Could've
to
done
pay
that.
the claim, that in and of itself would not have been outrageous. But what made it outrageous was that there was some sort of internal, decision made that they're just not going to pay it for a certain period of time in the hopes that the plaintiff would die. I agree with you that made that particular case, rise to the level of outrageousness. Your Honor, frankly, the statement by the attorney in this case doesn't come even close to that level of outrageousness. I mean, you're talking about, withholding medical care in the hopes that somebody dies so you don't have to pay for it. I mean, I don't think any of us sitting here would not find that to be outrageous. We're talking about a statement by an attorney, sort of, boilerplate and generic, just expressing that he hopes that the search is successful and whatnot. I don't really equate those two. I mean, I do agree with your point, Your Honor, that the context is important. We do have to consider the context as alleged in the complaint in this situation. But I would just submit to Your Honor that even considering that context within the complaint, the attorney's statement is not outrageous.
You have about 5 minutes left in your argument.
Okay, thank you, Your Honor. So I'll move forward, Your Honor. I know we filed a motion and Your Honor has read it, so I'm not going to try to belabor too many points here. But with regard to the assertion of legal rights, really, the plaintiffs recognize that the Laundries have constitutional rights, and that the conduct that they have alleged within the complaint is really an exercise of those rights. So what they argue in response is that the court on a motion to dismiss shouldn't consider certain things. Number one, because they allege that within the complaint, they haven't alleged state action. Number two, that they haven't alleged any constitutional rights within the complaint. And so the court shouldn't consider them. And then fourth, that the constitutional rights are affirmative defenses. Your Honor, with regard to the state action argument, as an initial matter, just because the government isn't trying to compel someone to do something doesn't mean constitutional rights don't go away. If you don't protect your own constitutional rights, even when the government's not trying to do something to you, then you would likely waive them. If the defendants in this case had made a bunch of statements, even if those statements weren't to law enforcement, those statements could absolutely be used against them. So, in that sense, Your Honor, those rights exist, irregardless of whether the state is involved. Your Honor, also, as a second point, there is state action involved here. And one of the cases we cited to Your Honor in our motion sort of sums it up. It's Gerber versus Longboat Harbor, North Condo.
The Michigan shooter case is a
It's
criminal
a Middle
case.
District of Florida case from 1991.
And also, to the extent there's a civil case, there's a civil cause of action, potentially for negligent entrustment.
Since it is not a governmental entity,
There is a potential cause of action there. There's no cause of action
all
here.
Of the functions of a governmental entity, the provisions of the
Is there an
First
extra Supreme
Amendment
Court
as
release on
incorporated
Friday?
in the 14th
That
Amendment
sucks.
simply do not apply. This court cannot agree with defendants' contention, and by applying the principles enumerated in Shelley versus Kramer, which is a Supreme Court case that sort of set forth that the third branch of government, the judicial branch, is also state action.
It sure is. Damn
This
it.
court found and continues to find that judicial enforcement of private agreements
You're right.
contained in a declaration of condominium
I'll be on the
constitutes
road,
state
so we'll give it a
action
try.
and
I'm not sure how that's going to
it
work.
brings the heretofore
Well, I'll be
private
fine. I'll be a
conduct
couple
within
hours
the
behind.
scope
I
of
can
the
make it work.
14th Amendment, through which the First Amendment guarantee of free speech is made applicable to the
I might have to
state.
do it in a
Now,
hotel
obviously,
lobby
we're
or
not
something,
dealing with a
but we'll
contract
work
here
out.
or a condo association or anything like that. But the point is the same, that when a party tries to use the courts to enforce something, then there is state action. And in this case, Your Honor, the plaintiffs want the court to enter a judgment against the defendants. They presumably will want the court to enforce that judgment. and they want to use the court's authority to compel the defendants to participate in the discovery process, all of which implicates their First Amendment, Fifth Amendment, all of their rights, Sixth Amendment right to counsel. So, Your Honor, in that regard, there is state action. I addressed the criminal investigation earlier, so I won't go through that again. Your Honor, with regard to the four corners of the complaint argument, like I said before,
Dave asks, is
the
Dobbs on
Laundries
the
are
next
residents
Supreme
of
Court slip?
Florida.
I have no
It's
idea.
alleged in the complaint.
Supreme Court doesn't
As
announce what
such,
decisions
the
they're going to announce until they
Constitution
announce
fully
them.
applies to them, and the court can consider those rights. The plaintiffs are essentially asking the court to force the defendants to go through discovery,
No affirmative duty
pretrial
would have really
proceedings,
helped.
summary judgment, just to get to the point where the court finds that the defendants have constitutional rights. That's just a waste of judicial resources and the resources of the parties. Your Honor, with regard to the affirmative defense, nobody cited any cases where the legally permissible element is labeled in an affirmative defense. I certainly haven't seen anything where it's the defendant's burden to prove that if there were to be a trial such that it would be an affirmative defense. Rather, the legally permissible element is really intertwined with the outrageous element. In the seminal case of
Yeah, the
Metropolitan
Petitos are
Life
there
versus
just for a
McCarson,
press
which is the Florida
conference.
Supreme Court case
They're just there for a
established
press conference in
cause of
order to say,
action.
we
The
want
court explained how it
justice,
applied in that
blah, blah,
case, and
blah.
it said the facts as a matter of law are not so outrageous in
Why does
character
constitutional rights
and so
need to be in the
extreme
complaint?
degree as to go
Well, if you
beyond
have a
all
right to something, you
possible
might want to
bounds of
mention it to a
decency.
court. That'd be
Rather,
helpful.
the insurance company, according to
If
the terms
if you're
of the
doing
policy,
something and
had
you have
the
a right to it, you might want to
demand
bring that to the
proof
court's attention.
of
That'd be probably
ineligibility
why you
from
would mention
Medicaid,
it.
or from Medicare. And then it goes on and it says, Metropolitan did no more than assert legal rights in a legally permissible way. As such, Metropolitan's
Gabby
actions
Petito is
are
dead.
privileged under the circumstances. So, Your Honor, it's not really a defense. It's really part of the outrageous calculus, the outrageousness calculus, that the conduct isn't legally outrageous if there is
No affirmative
privilege
duty.
or
I
a
don't
legal
really
right
like.
that-
I mean,
that's being
what he's doing
asserted.
is okay, but
And Your Honor,
the
we
fact that
cite
he
some
is just
additional
screaming
cases
no
in our
affirmative duty
reply
over
that
and
I'll
over and
rely
over
upon in
again,
that regard.
and just has like a sign that
Your
says
Honor
it that you could hang
also
up
said
off
that
the
even
front
if this is
podium
an affirmative
is
defense,
really just a
which I don't
misstep.
think it is, the court can consider an affirmative defense if it is apparent from the face of the complaint. Your Honor, we would argue that constitutional rights are apparent from the face of the complaint. They allege a crime was committed. They allege an attorney was hired. So it's not a situation where the court can't consider the defendant's constitutional rights. And in fact, in the case Huzzar versus Gross, which we cited in our papers,
Yeah.
it's the first DCA
Scotts
case
blocks
from
tomorrow
1985.
and
It's a
Friday.
defamation case.
Yeah.
And in that case, the court was considering a
And
First
presumably
Amendment
next
privilege
week
on
as
a
well.
motion to dismiss, and held that
they've
trial
got,
courts,
what,
upon
13
motions
left?
to dismiss,
They're
routinely
gonna try to
make
squeeze them all
decisions
out
as
in the
to
next 2
whether a
days?
privilege applies to protect an allegedly defamatory
If
statement.
the judge
So
says
again,
no,
in
is
that
it done?
in that
It's done.
context,
They could
the court
appeal,
held that on a
but they're
motion
going to lose that
dismiss,
too. If the
court can
judge says
consider
that they're done,
a
they're done.
constitutional right of a defendant,
Then
if
it's
that
off to appeal, where they're also
constitutional
more
right is their
done.
defense.
Okay, well, let's just ask. I know you have identified what you contend is one crime, which is to actively assist Brian evade capture, essentially. Assuming, of course, that and not there's
Is the man hurting the great motion? Not in particular. He's just not really doing as well as I think he could, because he's not screaming no affirmative duty over and over and over again.
Assume, for the sake of argument, that is sufficient for purposes of us to find that there was some sort of active.
Get a damn pin that just says it
crime,
right on
if
your
you will.
lapel.
Is there any other crime that the Laundries have been accused of or could potentially be accused of? Because before you can invoke a constitutional right to remain silent, there's got to be a crime, right?
Oh,
Well,
bullshit.
Your Honor, there doesn't necessarily have to be a crime. You just
don't
have,
have
to
to-
believe that you might be in jeopardy of a potential investigation.
Well, doesn't the case law talk about it has to be a chain in the causation towards a crime?
Your Honor, I don't disagree with you on that point. What I'm saying though is there doesn't have to be a formal investigation. If
That's
I
why.
left this
That's why
courtroom
going with the Fifth
and
Amendment right is a
committed
bit of a
crime
mistake.
and nobody knew about it.
It's like
I'm
this
not
isn't.
obligated.
It's no
to
affirmative
go
duty.
confess that crime.
I don't have. I have no obligation.
I can assert my silence for as long as I feel
So
like
you
I
avoid
need
this problem
to protect
completely.
myself.
Well, let me ask you this, because the case law I'm familiar with is in a deposition, the Fifth Amendment would have to be invoked as to each specific question.
The Fifth Amendment is
So,
not the
for
relevant
instance, if
issue.
the question is, what is your
I'm not even
name?
sure they put Fifth
You might
Amendment in the
not have
briefing.
a
They talked
Fifth
First Amendment, not
right
Fifth.
to not answer that,
I don't think they
depending
talked
on
Fifth
the
Amendment. They
context
talked First
of
Amendment.
the alleged crime.
It's like, Your Honor, unless
So,
I'm mistaken,
I
it's
get
like the
back
correct
to what
answer
is
here
the
is, Your Honor,
crime
we're
here?
not talking about the Fifth Amendment. We're talking about the First
And
Amendment.
Isn't that really something that we
The
need
right to
more
not
pleadings
speak
to be able to
is a First Amendment right.
accurately
So
identify?
Your
that
Honor's
I have a
analysis is
better
what we call
standard
inopposite,
as to whether
or to
not
put it another
your
way, dumb.
Fifth Amendment argument actually is applicable?
I don't think so, Your Honor. I mean, certainly the plaintiffs have alleged criminal conduct, most of which by Brian Laundrie. I'll agree with that. But they do allege that the Laundries, potentially were trying to assist Brian Laundrie in leaving the country, which could be an obstruction, could be something else.
Could be an accessory.
Again, we're not leaving the complaint when we talk about that. And so in that regard, the defendants still wouldn't have an obligation to speak about other things that may be sort of tangentially related to the whole situation. If there is potentially a crime involved. I mean, Your Honor, in Miranda versus Arizona,
Sandy said, what did they decide? I don't know, Sandy. We're watching the hearing. How would I know what they decided? We're literally watching it.
The person is guaranteed the right to remain silent unless he chooses to speak in unfettered exercise of his own free will. So it's the defendant's exercise. It's not something where, the defendant can maintain his silence only with regard to certain things. If he's not being compelled to answer questions, he doesn't have to speak, period, at all. Again, from Miranda versus Arizona, the privilege has come rightfully to be recognized in part as an individual's substantive right, a right to a private enclave.
I think you're a little bit off
where
point
he may
here on
lead
Miranda,
a
to be
private
honest.
life. That right is the hallmark of our democracy.
It's not bad. It's
So
just
again,
not
Your
optimal.
Honor, it's not. In Miranda versus Arizona, the court wasn't parsing what questions a defendant can or cannot answer. They said the right is a private enclave where a person can lead a private life.
The hearing is
They can
over.
maintain
Well,
that
then
privacy
presumably, if you
for
don't
as
know,
long
then they
as they're
need
able.
reserve judgment.
Now, of course, like there are certain situations if defendant is subpoenaed to testify.
So he's not going to do it from the bench
perhaps,
today, which is disappointing.
Certain questions could be parsed, like what the person's name is or something, as long as that's not incriminating, which in some contexts it is. This is again, going to the plaintiff's argument, they haven't alleged that anybody was compelling anybody to do something and they refused or something like that. In that context, everybody.
Thank
has
you
the
for the
right to their
1,000 of you who
private
are currently
enclave.
watching, by the
They
way.
don't have to come and
As always, it
affirmatively
is
state
appreciated. If you're not already
everything they know
subscribed,
about
if you
everything.
hit that subscribe button, it's
That's
always
just
appreciated.
not the
Thank
way
you.
our society works. It's
They just
not
wrapped
the
up their
way,
press
it's
conference.
not how the Constitution works. People are protected until they're not.
This lawyer's
and so
not bad
that-
for someone who
in
asked me
my
to rate the
opinion, Your
lawyer.
Honor,
He's not bad. He
um,
just could be doing better.
I don't believe
5
that
out of
the
10, 6
Laundries
out of
would have
10.
an
He's doing fine.
obligation to provide
He's
certain
also ran.
information
He's fine.
and not provide other information that they can withhold all information until it's compelled of them. That's or they're provided immunity by the government or whatever the circumstance might be.
Well, let's put a pin in that right now so I can hear from your opponent.
Yes, Your Honor. And Your Honor, for our remaining arguments, we'll just rely upon our papers unless the court has some specific questions that you'd like to address.
Thank you, sir.
Fair enough. All right. Petito lawyer.
May it please the court.
Uh-huh.
Your Honor, this case is not simply about the silence of Christopher and Roberta Laundrie, who
Great.
knew that their son had brutally murdered
Speculation.
Gabby Petito. It's not simply about their callous refusal, despite pleas from the Petito family,
No affirmative
to speak
duty.
up about whether or not Gabby was alive and if she wasn't, where her body was located. It's about a course of conduct that they committed from the moment they learned on August 28th.
What conduct did they commit towards the
Laundries
Laundries
had
or to the
murdered
Petitos?
Gabby Petito up until the time that her body
What
was
conduct
found.
did they
And
commit
as this
towards the
court
Petitos?
has already noted and pointed out, that includes the statement that was made.
The statement is not outrageous.
To speak up, they spoke up through their attorney, and I'll touch upon the
The
importance
statement
of
is
that
not
in a little
outrageous.
As the court knows, you're bound to accept as true all of the facts alleged in the four corners of the complaint.
I have no problem with
And I'd
that,
just like
counselor.
to review what some of those allegations are.
Sure.
Well, let me ask you this, Mr. Riley. And let's lay aside the statement that the attorney made on behalf of the Laundries. What duty did the Laundries have to do anything to help Mr. Petito?
Thank you. Someone's going to mention it at some point. Damn. Shit. I mean, the defense, the lawyers for the Laundries aren't going to mention it at any point, mention the word duty. The word duty never appears once. But the judge knows what's up. Thank God. Where's the duty? Serious question. Do you have Asperger's or autism? Serious answer. Timeout. Let's go on. Also, fuck you.
Petito and Ms. Schmidt.
That's a fair question, Your Honor, and I've struggled with the answer to that particular question. And I guess maybe by answering this, I'm deflecting, but my answer is this. It's about what they did with the information that they have.
Whoa, 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 whoa. Let's try this again. Let's try this again, counselor.
Particular question, and I guess maybe by answering the question, Your Honor.
Mr. Petito and Ms. Schmidt.
That's a fair question, Your Honor, and I've struggled with the answer to that particular question. And
I bet you have. I bet you have, because the answer is they don't have one. I bet you have struggled.
And I guess maybe by answering this, I'm deflecting, but my answer is this. It's about what they did with the information that they have, not just not disclosing what they knew to the Laundries. And by the way,
what did they do with the information they had other than not disclosing it?
They could have, the Petito family, excuse me, they could have made an anonymous phone call. And
what duty did they have to make an anonymous phone call?
Where the body was located, and that would have helped this situation tremendously. They knew starting on August 28th of 2021 that Gabby was dead. They knew where Gabby's body was.
Speculation.
They knew that the Petito family was desperately searching for information.
Sure.
But they did things affirmatively.
Like
they didn't
what?
just remain silent.
Like what?
Brian Laundrie came home in Gabby Petito's van
Okay.
by himself to his family's home. That family, knowing that Gabby was dead, knowing their son had murdered her,
Speculation.
knowing where the body was, and
Speculation.
in particular, knowing that Joseph Petito and Nicole Schmidt were desperate to learn where their daughter was located, they went on vacation.
That is not something they did to the Petitos. Your case is based on rank speculation. You have no evidence, none, that they knew. None. You know that Laundrie came home. You know that the Petitos were searching for them, but you have no evidence, none, that the Laundries knew that Brian Laundrie killed Petito. You have no evidence, none, they knew where the body was. Speculation. Speculation. They went on a vacation. They didn't do anything to you. No duty. No duty. Unbelievable.
They assumed and continued their normal life as though nothing had happened, while this family was suffering, wanting to know where their daughter was. Not only did she not.
Let's get back though to legal duty.
Thank you, Judge. Thank you, Judge, for getting back to the issue that matters. Where is the duty? Where is the obligation? Attorneys for the Laundries can't be bothered to mention the word duty. But the judge knows what's up. The judge knows what's up. Let's get back to duty. That's a great place to go. Let's do that. Thank you for the 100K thing.
I hear what you're saying, that these facts might sound bad, but we're not talking about social mores here. We're talking about legal duty.
Thank you.
We're talking.
So let's try to focus in on what duty did the Laundries have? What did they owe to Gabby's parents?
Well, let's put in perspective what the relationship was, Your Honor. These
That's not the answer to the question. What duty did they have? Well, let's put in perspective their relationship. That's the wrong answer. The only way let's put into perspective their relationship makes sense is if the next sentence out of your mouth is the Petitos are the minor child of the Laundries. But since they're obviously not,
these people were not strangers. These people
legally they are.
Their son was engaged to marry Gabby Petito.
Uh-huh.
Gabby had lived with them for about a
Uh-huh.
year. They had both visited Joseph Petito's home and Nicole Schmidt's home. They were cordial. They had a cordial relationship, a warm and friendly relationship. They knew how much Gabby meant to Joe and to Nicole. Going to the issue of a duty.
Discount Robert De Niro over here isn't doing a very good job of answering the question, I have to say. A lot of me. Just answer the question. Oh, you can't. That's right.
Your Honor, I struggle with that. I admittedly, it's difficult to say what it is.
Yeah, it's really, really difficult. Extremely difficult because there's no answer.
And that's why I'm saying there was a course of conduct that they did that was outrageous, culminating, in my view, in the statement that was made by their attorney, who, as Your Honor pointed out, is their agent. And what that attorney said in particular is telling. So there's no question that he.
So, yeah, the only thing you have is the attorney making the statement that they hope for the safe return. And that's an outrageous statement. No. There's nothing for a jury to do, by the way. Because on a motion to dismiss, you just assume all the facts are true. You assume the worst possible case. I mean, anything that can be proven. So sure, you can assume that the Petitos authorized the attorney to make the statement about hope. It just doesn't get you anywhere.
He represented that he was making that statement on behalf of the Laundries because he says, it is our understanding that a search has been organized for Miss Petito in or near Grand Teton National Park in Wyoming on behalf of the Laundrie family. It is our hope that the search for Miss Petito is successful and that Miss Petito is reunited with her family. That statement was issued with the full knowledge and consent of the Laundries.
Sure,
the full knowledge on the part of the Laundries that Gabby was not alive and that Gabby's body was located somewhere out west. And instead, they make a statement saying, we hope you find her. We hope you're reunited. Giving them false hope that perhaps their daughter is still alive. If that's not outrageous, Your Honor, I don't know what is outrageous.
And you don't know what's outrageous.
So I think when you talk about their affirmative duty to speak up, I struggle with that. But they did speak up. And when they spoke up, they made that very callous, that very terrible statement, giving hope to Joe and Nicole that perhaps Gabby was still alive with full knowledge that she was not. And Judge, when I talk about the course of conduct, I want to talk about some of the cases that I cited in my response to the motion where the court found that there was outrageous conduct. And I don't see how any of these cases are by any stretch of the imagination worse than what happened in this particular.
Really? Okay. All right. So, okay. Let's just fully comprehend his premise before we move on. All right. Let's fully comprehend his premise before we move on. He says, okay, I'm going to cite some precedent. That's a good thing for a lawyer to do. It's always a good thing for a lawyer to do. And he's going to say these cases in the past are like this case now. That would be great if true. So he has now set himself up. He's now set himself up and says, Your Honor, I have a whole bunch of cases And these cases, I don't see how this case that we're talking about right now isn't even worse than these other cases in the past. Okay, counselor, sell me. Sell me how this case is worse than these precedential cases. What are these precedential cases you have? Let's see which is worse by comparison. Okie dokie. Okie dokie.
Case. In the McAlpin versus Sokole case, a patient went to a hospital to have an x-ray done. She put on a hospital gown. She walked into the x-ray room, and the minute she walked into the room, the doctor began berating her in front of other staff because she hadn't paid another doctor's bill. He told her he wasn't going to treat her, and he told her that he was going to call security and have her removed from the hospital. That, according to the court, was outrageous.
Is this worse than that or not? What else you got, counselor?
In Nims versus Harrison, a teacher, two students of a teacher wrote, published, and circulated a newsletter in which they had an article called Low Life, and they referred to that teacher in offensive language, threatened to kill her, threatened to rape her children, and threatened to rape their cousins. Outrageous.
Okay, again, this case is worse. This case we're talking about right now, the Petito case, is worse than that case. That's the proposition this lawyer's trying to sell you on. He just told you that. He's trying to sell you on the proposition the Petito case is worse than the child rape sex case. Okay, what else you got?
Ford Motor Credit Company versus Sheehan. Collection agent is unable to locate the debtor. Contacts the debtor's mother, tells the debtor's mother that she's from a hospital out in California. She's trying to locate the debtor because two of the debtor's children have been in a serious car accident, and she wants to find the debtor so that she can let him know about this accident. The son speaks to the mother later that day, hears the story from the mother, spends the next 7 hours calling hospitals and police departments out in California, only to find out that this story was false. That was outrageous.
A woman from Ford Motor Credit trying to collect on a bill calls the debtor's mom, says the debtor's kids have been in an automobile accident and need urgent medical help. The debtor then spends the next 7 hours trying to locate his own kids in order to collect on a debt. This Petito case is even worse than that. That's the proposition this lawyer is trying to sell you on. Is the Petito case worse or not than that case? Hard to tell.
The Dependable Life Insurance Company versus Harris case was talked about previously. In Liberty Mutual versus Stedman, the company delayed authorizing a lung transplant, even though a judge of compensation claims had already ordered that they pay for the lung transplant. The carrier knew she would die without the lung transplant. So, hoping the problem would go away, they denied payment in an effort to intentionally induce stress on her part to speed up her demise. The court said, under the totality of the circumstances, it's outrageous.
Person needs a double lung transplant. Insurance company has been ordered by a judge to pay for the double lung transplant. Defying the court's order, the insurance company intentionally intends and attempts to inflict upon the patient stress so the patient will die sooner so that they don't have to pay for the lung transplant. Is the Petito case more outrageous or less outrageous than the insurance company trying to purposefully induce the stress on the double lung transplant person? This lawyer is trying to convince you the Petito case is worse. This lawyer is trying to convince you that when the Laundrie's lawyer said, "We hope you find your daughter," and you're reunited, it was worse than when the insurance company, having been ordered to pay by a judge for a double lung transplant, said, "Nah, how about instead of that, how about we purposefully induce stress in this person in the hope that they'll die so we don't have to pay?" Which is worse? Hard to tell. Let's read some more.
Williams versus Mineola, and it's these two last cases that I'm going to cite the court to that I think are most instructive here. In Williams versus Mineola, police officers attended the autopsy of a teenage boy who had been murdered or committed suicide, and they were there with a videotape, a video camera, and a camera to record it because of the suspicion that a crime may have been committed. They took that video, they took those photos, and they took them to a party. And at the party, they shared them with other persons, including other police officers from surrounding jurisdictions, and they laughed and they joked about what was in those photographs.
Cops take photographs and video of an autopsy. They then take the photos and photographs and video of the autopsy to a party with other cops, show the photos and video of the autopsy to the other cops, and they all laugh about it together. More outrageous or less outrageous than the Petito's lawyer saying, "We hope you find your daughter." Again, so hard to tell. So hard to tell. This is a million times worse. Okay.
The court found that to be outrageous, and here's what the court said. As for what is outrageous or reckless or what is not, we emphasize that our society, as reflected, for example, in decisions of the courts of Florida cited earlier in this opinion, shows a particular solicitude for the emotional vulnerability of survivors regarding improper...
How is Discount Robert De Niro making this argument with a straight face? How can he seriously go up and say this is worse than all that? I mean, okay.
Behavior toward the dead body of a loved one, and the special deference paid by courts to families' feelings where rights involving dead bodies are concerned is central to our decision. This area is unique, and once it is entered, behavior which in other circumstances might be merely insulting, frivolous, or careless becomes indecent, outrageous, and intolerable. One obvious reason is that the bereaved are already suffering psychic trauma because of the loss of the loved one, and are especially sensitized to any disrespect or indignity directed at the deceased body or a representation of it. The potential for severe emotional distress is enormously increased in that situation. All of this is well known to the ordinary person, and so a level of carelessness or callousness, which might not be considered tortious in other situations, can show outrageousness and recklessness when a dead body or a picture of a dead body is involved.
Well, Mr. Riley, how is a statement, "We hope this search is successful," how is that in itself outrageous?
It's a lie.
Great question. Great question.
It's said with knowledge that there's no hope of finding her alive because she's dead. It's said with an intention to give false hope to a family that their daughter may be alive. That's outrageous.
No, it's not.
And at this particular point in time, they had been begging the Laundries to tell them where their daughter was. And this is the statement that they issued the one time they chose to speak up. This was the statement that they issued. A lie that gave false hope to...
It's not a lie. It's not a false statement of fact. It doesn't even imply a false statement of fact. We hope the search was successful and you're reunited. Doesn't necessarily imply that they're alive. I mean, people do want to find dead bodies too. Whose lawyer is this? Discount Robert De Niro over here is fighting for the Petitos, looking very sad in the back, which is their sole reason of being here, is to look sad.
Gabby's parents that perhaps she might be alive. The other case, Your Honor, that I think is instructive is the Thomas versus Hospital Board of Directors.
Oh, this should be
case,
good.
and I think this one may be even more instructive.
Okay, this one's going to be even more instructive. Okay, tell me something even more instructive, which I guess on one level isn't hard since none of it's been instructive so far. So, okay, let's go with that.
In that case, during I believe it was a hip transplant surgery, the decedent died. She died of cardiac arrest. What she really died, the real reason she died of cardiac arrest is because she was given an overdose of a particular medication during the surgery. And the doctors and the nurses agreed that they would not report the true reason for why she died. They would say that it resulted from complications of surgery. As a result, a complete autopsy was not done. The body was released to the family, and less than a week later, as the decedent's daughter was trying to bury her mother, she received a telephone call from the medical examiner saying, you need to bring that body back immediately. We have to perform a complete autopsy. Again, the court said that was outrageous. And what the court said was, we believe that the appellee's conduct in making false statements.
Maria says, why am I so down on the Petito's family? I'm not saying anything other than what's true. The only reason for them to be there is to look sad in the background. That is the reason for them to be there. There's no reason for them legally to be there. I haven't said one thing that's not true. Their sole reason to be there is to be there and look sad in order to gain sympathy and empathy. That's just true. That's not being down on them. That's the reason they're there. There's no other reason than to be. The reason that they're there is to look sad and gain empathy and be in the back of the shot. That's the only reason for them to be there. Does that mean being down on them? It's just me saying that's the reason they're there. They're there as a prop to be an emotionally manipulator. There's no reason for them to be there except for that reason. Is that me being down on them? That's just me saying that's the reason they're there.
And isn't that what Mr. Bertolino did on behalf of the Laundries here? We believe that the appellee's conduct in making false statements which led to the interruption of Mildred Thomas's funeral and the return of her body for a second, more thorough autopsy rises to the level of atrocious.
Do you think the reason is to listen to the hearing? You think the reason that they're there is to listen to the hearing? It's unfortunate then that the hearing wasn't broadcast so that they could listen to the hearing. I mean, if that was the reason for them to be there, so they could listen to it. I mean, it's unfortunate it wasn't broadcast so they could listen to it that way. Oh. Why are they there physically? Oh, yeah. No.
And utterly intolerable behavior which cannot be condoned in a civilized society. As noted in Stedman, when an actor has knowledge that the other person is peculiarly susceptible to emotional distress, and the Laundries knew that because this family publicly said they were distressed trying to find their daughter, the actor's conduct may become heartless, flagrant, and outrageous when the actor proceeds in the face of such knowledge. We believe that in a situation where a person's love...
Dooley said maybe they wanted to be there. For what reason? As Miss Petito grasps her cross and rubs it with her fingers. She wanted to be there. Why do you think she wanted to be there? As she grasps her cross between her fingers and rubs it with her eyes closed. Why do you think she wants to be there? I'm thinking it's because she wants to be there so that she can look sad and mournful and gain sympathy. I think that's her motivation for being there. That's my impression of her reasons for being there, based in part on literally what we're seeing right now with my own eyes. Yep. Okay, I'm good.
One has died, it would be apparent to anyone that the person would be susceptible to emotional distress and therefore that the action of...
Someone said, I'm sorry to disagree with you, Kurt. I believe what they did was terrible and heartless. I haven't given you anything to disagree with. I haven't given you anything to disagree with. What do you mean you disagree with me? That they're terrible and heartless. I haven't given you anything to disagree with. I don't recall at any point saying that I thought what they did was good or right or correct or heartful or... I don't recall using any... I haven't given you anything to disagree with. What do you mean you disagree with me that what they did was terrible and heartless? What are you disagreeing with me about? What if I said that either agrees with this or contradicts it? I haven't stated a moral posture. I haven't stated that what they did was good or right or that's terrible and heartless. I haven't stated a position either way. What have I given you to disagree with?
providing false information concerning the loved one's cause of death meets the standard for a claim of outrage. In this case, they provided false information, a false impression, knowing that Gabby was dead, that she was still alive and she could be found by the family if they were searching in the right place. So I also think under the restatement of tort section 46, comment F says, the extreme and outrageous character of the conduct may arise from the actor's knowledge that the other is peculiarly susceptible to emotional distress by reason of some physical or mental condition or peculiarity. The conduct may become heartless, flagrant, and outrageous when the action proceeds in the face of such knowledge, where it would not be so if he did not know. And that's basically what the Williams court was saying. And that's what I'm saying in this instance. The Laundries knew of the fragile emotional state of Joseph Petito and Nicole Schmidt at the time that that statement was issued. They knew that she was not alive. They knew that the family
Speculation.
was hoping to find her. And they put out a statement as though they were supporting them, saying, we know she was our son's fiance. And we hope that you find that body too, or you find her and the family is reunited. Excuse me. That's callous. That's
No, it's not callous.
It's shameful, and it's
none of those
outrageous.
things.
And by the way, the only reason that Mr. Bertolino is not a defendant in this action is because he's not a citizen of this.
Good Samaritan law. Someone brought up Good Samaritan laws. Good Samaritan laws, where they exist, are a immunity from liability that would otherwise exist. Good Samaritan laws provide immunity for action. So they exist, for example, if a good example would be you see someone, you're just a random person. You don't have any specialized training, or you're not licensed in any way. And you see someone choking and you give them the Heimlich. Whether you succeed or not, a Good Samaritan law would absolve you of any harm that you caused. So maybe you succeed, maybe you don't. Maybe you succeed and you break their ribs or whatever, right? So Good Samaritan law gives you an immunity for liability you would have from action. So you would otherwise have liability from action. A Good Samaritan law provides you immunity from that action because you did it for, Good Samaritan-like reasons. Good Samaritan laws do not require you to do things. Good Samaritan laws only absolve you for making decisions to do things. They don't require you to do things. It's a common misunderstanding of the laws.
Citizen of the state of Florida. I think there's also support for our position under comment E to the restatement, which says unequal position of the parties in a relationship where one asserts and has the powers to affect the interest of the other may also supply the heightened degree of outrageousness required for a claim of intentional infliction of emotional distress. Here, the defendants clearly had the power to affect the interests of the plaintiff because they could have told them where her body was located.
Actually, Kathy, it's exactly the opposite way around for the Good Samaritan laws. That's why I made a point of saying that they weren't licensed. If you are licensed, Good Samaritan laws typically do not apply to people who do have licensing. So again, it's a state-by-state specific thing, but I made a point of saying that they were unlicensed for a reason. If they have license, if they're a licensed DMT, if they're a licensed doctor, and they cause harm, Good Samaritan laws typically do not apply to licensed professionals. Again, it's a state-by-state thing, so they may apply in your jurisdiction, but as a general rule, they don't. Good Samaritan laws typically only apply to the unlicensed and untrained, not to the trained. So, so it's exactly the opposite. In fact, only the non-medical professionals typically get the immunity from the Good Samaritan laws.
And they chose not to do so. Your Honor, I don't think there's any question. There's been nothing raised, at least by counsel in his argument, that the conduct didn't cause severe emotional distress to my clients.
Yeah, we definitely contend that because it can't cause it because it didn't happen. Things that don't happen can't cause things.
To the extent that they would suggest and have suggested, well, they were already distressed anyway. So all we did was increase their harm. I guess it's okay to kick someone when they're down, according to the Laundries.
If you actually kick them, we'd have a lawsuit. Physically, literally, or metaphorically. Obviously, literally, we'd have a battery. Metaphorically, we'd have a something. But the not kicking, yeah.
But going back to those two cases that I cited earlier involving dead bodies, the parties were
okay. Crip Lord says You say we assume everything is true, so surely you can't use speculation or refuse a claim, but you keep doing it. Am I missing a nuance? You are a little bit, and I'm happy to clarify, actually. So you can't just, all right, so you can assume things, it's complicated. In Florida in particular, they have a fact-based pleading system. So Florida in particular, and this would probably be true in other states, although it's more true in Florida because again, this is an operation of state law. Florida has a fact-based system. So you can't just be merely speculative. You can't be merely speculative, merely conclusory. You can't be that in the federal system either. You have to have some evidence or some reason to believe the thing is true. Like you have to have a reason other than just pure wishing it into existence. You can't use a lawsuit as a fishing expedition is sometimes the phraseology you'll use, right? You can't just use pure speculation to get to a lawsuit. You need to have something that is somewhat related to reality, for lack of a better description. So there is a nuanced point here. In Florida in particular, this nuanced point seems to require a little bit more than it might require in other jurisdictions. So Florida seems to require a little bit more in their pleadings in terms of what the legal requirements are. And so it seems to be true, particularly in Florida, but I think this would be generally true in most other places, right? You can't just say, oh, the laundries know. Like you can't just say the laundries know that the son told them that Gabby Petito is dead. It's like, what basis do you have to believe that? And like you can believe that based on some other thing. Like, so you can get a lot further in terms of like the speculation system. So like, if you could show they did a thing that would be responsive to that specific knowledge, that would help. So if you could say like, okay, the kid comes home, they meet them and the Petitos go out and I don't know, do something that would show action based on that knowledge, then you can infer the underlying knowledge, right? So you can infer the knowledge based on the action, right? But you can't just completely speculate it into existence from nothing, right? And in Florida, you seem to need a little bit more. So there is a nuanced point here. You can't just completely make up facts. It's you need some good faith basis, for lack of a better description, to believe it. And you can't just go on fishing and be like, well, they must have told them. It's like, you can't just assume that from nothing. You're conjuring it out of nowhere. If they had done a thing that showed that they had underlying knowledge, if they had told someone, or like, if there was some sort of behavior or some sort of action that would lead you to some sort of plausible basis that says, oh, they must have had this underlying knowledge. But here you don't even have that. So there is a nuanced point in general, and Florida in particular seems to require things to be even a little bit more specific than that, based on my understanding of the case law from reading the briefs in this case. So hopefully that kind of makes sense, but there is a nuanced point here. But it was a very good question. Thank you for asking it.
Already grieving, and it was the conduct after death that the court found was outrageous and permitted the case to move forward. So I think we have the issue of their conduct was intended to harm, or certainly what they did, they should have known was likely to cause severe emotional
and
distress.
Again, you even have a bigger problem. Like, even the speculation isn't the biggest problem. So if you want to disagree with me on that, which, fair enough, we can even do one step better. Like, I can even do one step better and just assume it into existence. It still doesn't matter. So I don't even need that, right? I say, well, first of all, it's speculation. You're conjuring it from nowhere. But let's say I'm wrong. Let's say I can conjure it from nowhere. Great. I'm not going to magically just conjure things into existence because I can. Fine. All right. So as a matter of reality, Brian Laundrie did tell the parents about the death. As a matter of reality, they tried to assist the son in some way. As a matter of reality, whatever. Okay. How do all these facts that I've now just created out of the nothing because I'm a magical sorcerer, how do these facts lead to a conclusion of IIED? They don't. Even if they helped him in some way, they're at best maybe responsible somehow at like wrongful death or something, although the death already occurred, so I'm not even sure about that. Or they're accessories after the fact, but that's a criminal thing. Like how even assuming all these facts I'm now just conjuring out of the ether, do I get to IIED? Even if they knew for an absolute fact that Brian Laundrie killed Gabby Petito, even if they knew for an absolute fact where the body was buried, as I sometimes say, and therefore what? And therefore what? So first of all, you can't just assume it into existence. Second of all, even if you do, and therefore what? Okay, they knew their son killed Gabby Petito. Okay, they knew where the body was. And therefore what? What's next? It doesn't go anywhere. Because as the judge pointed out, no duty, no obligation. It doesn't matter. Even if I conjure it out of the nothing, it still doesn't matter. So, yeah.
To my clients, we clearly have an outrageous conduct on their part. I think we have established that the conduct caused more emotional distress. It doesn't have to be the only cause of their distress. If it increases, that's sufficient to recover. And I don't think they're contesting at all that the emotional distress was severe.
Sure.
So I'll move on to the suggestion that the defendants get to raise affirmative defenses at this point in time.
They can.
Well, and thank you for doing that, because my question there is, I mean, the rule is that I can address it if it is apparent within the four corners, and effectively you alleged conduct which arguably could be considered criminal on behalf of the defendants. So why can't I consider the Laundrie's constitutional right to remain silent and other constitutional rights within the context of ruling on this motion to dismiss?
Well, Judge, I'm curious to find out what conduct it is that the complaint says the Laundries committed that was potentially criminal. So if the answer is they were harboring a fugitive, there were no charge. Again, we're outside the record, but to my knowledge, or outside the four corners of the complaint, but the complaint doesn't allege that there were any charges pending against Brian Laundrie at the time. So they couldn't have been harboring a fugitive. Are they?
I'm not sure the absence of charges is the criteria that we use.
Well, Judge, what this is forcing me to do to address that is to go outside the record, which is not what we're supposed to do, to say he wasn't running. According to everything we know, the police knew where he was. So he wasn't a fugitive, so they weren't harboring a fugitive.
What?
I don't know what were the accessories after the fact. I don't know. Is there something they want to confess to? I'm happy to hear it, but
I'm sure you are.
Anywhere within the four corners of the complaint, there's a suggestion that the Laundries were under investigation for a crime or that they had committed a crime. So first of all, I think we shouldn't even be considering this as an affirmative defense. Secondly,
I don't have to consider it as an affirmative defense.
You can't look
no
at
affirmative duty. I just stamp it.
Was there an
My entire opinion
investigation
can be
into
3
them,
words long. No affirmative duty. Stamp it, send it.
So I don't think
Ship
the
it,
Fifth
send it,
Amendment
baby.
applies. If we turn to the First Amendment, I will tell you I strongly disagree with counsel's assertion that it applies in all instances.
What?
The defendants rely on Woolley versus Maynard for the proposition that they have a constitutional right to say nothing. But Woolley says that the right of freedom of thought protected by the First Amendment against state action includes both the right to speak freely and the right to refrain from speaking at all. And we're not talking about state action in this case. The defendant says we're asking the court to force the defendants essentially to say something. That's not what we're doing. We're seeking damages for their conduct.
Which is not saying things. What?
Importantly, the First Amendment does.
Mr. Riley, though, I want to direct you back to paragraph 30 of your complaint, where you say that the defendants were keeping the whereabouts of Brian Laundrie secret, and it is believed were making arrangements for him to leave the country. So that's something that the plaintiffs themselves injected into the case. So that's the basis of my question is, now that you've put that fact into the four corners of the complaint, isn't that the basis for me to consider, without having to need a affirmative defense filed, if you will, the constitutional rights of the Laundries?
Judge, what's the crime committed there? What's the crime that if they are making efforts to try to remove him from the country? He's not been charged with anything. He's
What? What? Didn't you say that they knew that he had killed her and they knew where the body was? What is the crime in trying to remove him from the country? What? The correct answer, among other things, for those of you playing at home, would be accessory after the fact.
He's not a fugitive. There's not, that itself does not suggest that they were committing a crime. There has to be an underlying basis. If the complaint said there was a warrant out for Brian Laundrie's arrest and the Laundries were moving money around to try to move him out of the country, I agree with you wholeheartedly that you could arguably consider a Fifth Amendment argument in this case. But there's nothing in there to indicate that there was any criminal conduct on the part of the defendant. There's a statement that says they were moving money around to try to get him out of the country. Is that unlawful as it's pled in this complaint?
When your complaint assumes from nowhere that they had specific knowledge that he killed her and knew where the body is, yeah, that looks suspiciously like it could be accessory. It looks suspiciously like aiding and abetting someone in the commission of a crime after the fact. Sounds suspiciously like murder. Yeah. I think that kind of suggests a crime. It seems to me, unless something's changed about the laws of Florida since I last looked or something. Holy God!
No, it's not.
Really? Well, that takes a relief off my head. Apparently, accessory after the fact is not a crime in Florida. This is a relief. This bit of legal insight has been brought to you by the attorneys for the Petitos over here. Would not necessarily recommend following up on that particular legal advice, however, if it were me. But okay.
Okay.
Going back to the First Amendment issue, Your Honor, it doesn't set forth an all-encompassing right to remain silent. Only where through state action they are being asked to espouse a religious, political, or ideological cause which they do not support, do they have that right. And I will cite to you from one of the cases in my brief, my motion, the Overbay case.
What the fuck are you talking about?
Says, freedom of speech includes both the right to speak freely and the right to refrain from speaking at all. At its heart, the right to refrain from speaking is concerned for preventing government from compelling individuals to mouth support for views they find objectionable or mandating speech that a speaker would not otherwise make. In other words, the court continued, the right to refrain from speaking limits the government's ability to sanction or override a private individual's preference for not making certain speech. Not all speech, certain speech. So let's look at Overbay.
Mr. Riley, you have 5 minutes left, sir.
Thank you, Your Honor.
That is a really fucking stupid reading. That is an incredibly stupid reading. It overrides their preference for making certain speech. Yes, specifically the speech that you're trying to force them to say at that moment. That would be the certain speech. You want to force them to say certain things, specific certain things. They'd like to not say those specific certain things. Their preference is to not say those specific certain things, which extends to all things, logically. He is blatantly misreading that. It only extends your right not to say certain things. Yeah, the certain things the government wants you to say, which implicitly means all the things. Shit, dude. Fuck.
Are the laundry suggesting that that we're seeking to compel them to mouth support for a view they find objectionable? Do they find it objectionable to tell a grieving family where their daughter's body is located and that
Perhaps they do find that objectionable. What's your point? Let's assume they do. I mean, people are allowed to have strange preferences. Let's assume they do find it objectionable. Are you going to say it's outrageous? Are you going to say it's outrageous for them to find that objectionable to them? That seems to be where you're going, right? Are they going to argue it's objectionable for someone to tell a grieving parent where the child of their body is buried? Okay, I mean, maybe that's their view. You're going to say that's extremely outrageous for them to have that subjective view? Christ.
that she's no longer alive? Do they believe that they would have a personal individual preference for not making a statement?
Okay. Chris says press play. Well, Chris, it's my channel and I'll press play whenever I please. Or not, because that's how I roll. They see me roll and they be hating. Know when I'm riding dirty. See me riding dirty. Riding dirty.
That they knew where the body was located? That's ludicrous. The First Amendment does not apply in this particular circumstance.
The First Amendment does not apply in this particular circumstance. Okay. Well, since apparently I don't have the right to not speak anymore, I guess I'm compelled to say that he's a dipshit. I didn't want to say that. I was going to restrain from holding that, but I don't want to upset his worldview where I'm not allowed to hold back anymore. So, you know.
We pointed out that they contacted counsel to show a course of conduct and to support our proposition that they knew that Gabby was dead and that they knew where her body was located as of August 28th. They immediately contacted an attorney.
I get back to where's the duty?
I'm adding a new channel rule. Anyone who tells me what to do on this channel in terms of playing content, not playing content, speaking, not speaking, gets timed out. You either like the channel or you don't.
Yeah. And certainly there's no legal prohibition on calling a lawyer.
I'm not, Judge, I'm not going there. I'm not I'm saying that's support for our position that they knew. That's circumstantial evidence, in my view, that's why it's in the complaint, goes to show that at that point in time they knew. I'm not being critical of them retaining an attorney. I'm not suggesting.
Yeah. No backseating the channel. New rule, no backseating the channel.
They shouldn't have. I like the fact that they retained Attorney Bertolini, and Attorney Bertolini said what he said on September 14th of 2021. So we're not saying they shouldn't have hired an attorney. We're not saying hold it against them for hiring an attorney. I'm simply saying they hired one immediately after getting a phone call from their son, who then returned home without Gabby. Circumstantial evidence to show that they knew. That's the only reason that I raised that issue about them hiring a lawyer. Your Honor, unless you have any other questions, I believe I've covered everything I wanted to cover.
Thank you very much.
Thank you.
Mr. Luca, I'll give you 2 minutes for any brief reply, but let's keep it to 2 minutes.
Yes, thank you, Your Honor. Your Honor, one thing I would point you to with regard to that city of Mineola case, Your Honor, there is a second DCA case, Crenshaw versus Sarasota County Public Hospital Board. I think it's cited in both my motion and the plaintiff's brief. And in that case, Your Honor, that case also involved a dead body, a stillborn child. And basically what happened is after the child was born, deceased, somebody within the hospital mutilated the child. It ended up going down a laundry chute. And in that case, Your Honor, importantly, the court noted that obviously if the mother had witnessed all of those terrible things that happened to the child, that might be one thing. But the court noted that the physically injured party should be directly involved in the event causing the original injury. If such a person sees it, hears it, or arrives on the scene while the injured party is still there, then that person is likely involved. And then they go on to say, here, appellant did not allege that she saw the mutilated body or that she was involved in the event, except for the birth of the stillborn child in any way. So, and Your Honor, that Stedman case was cited in Mineola, and in Mineola, the fifth DCA said that to the extent that Stedman conflicts, they're not going to follow Stedman. But Stedman would control here because it is a second DCA case. And lastly, Your Honor, I didn't raise this, get time to raise this initially, but I would point Your Honor to another important case, which is MM versus MPS. It's a third DCA case from 1989, again cited in the papers. And although not perfectly analogous, that case is instructive because it involves the parents suing the defendant for something that was done to their daughter. And in that case, the defendant told the parents that he had sexually abused their daughter, but obviously the parents were not present for the abuse. In that case, the court found that the appellants were not present when the alleged mistreatment of their daughter took place and may not claim emotional distress for her injurious or offensive treatment. Now, the plaintiffs countered that the disclosure of the treatment of their daughter was what caused their emotional distress. And the court said, after reviewing the law, we are unable to conclude that learning the awful truth from the defendant afforded appellants grounds for recovery for their own distress. And the court said, if courts were to allow relatives of tort victims compensation for the distress they suffer when they receive bad news about family members, when there is no attendant intentional or reckless conduct directed toward them, an avalanche of litigation would ensue. Compensation is available for actual harm to the victim. Only in carefully prescribed circumstances is compensation permitted for relatives who suffer emotional distress. It is not lack
Did you not
of
hear the court?
compassion,
You gotta stop
but
talking.
necessity that restricts relief to the immediate victim. And Your Honor, in this case, I would just submit to Your Honor that allowing a cause of action like this to proceed would create an avalanche of litigation that the tort was never intended to cover. Thank you, Your Honor.
Thank you both for your arguments. I will do my best to get a written order out within 2 weeks of today. Anything else in this first case before we recess the first case?
No, Your Honor. No, thank you, Your Honor. May I be excused?
Yes, sir.
I don't represent any parties in the second case, so.
That's fine. While he
Okay, well, we're not going to cover the second case because the second case concerns the lawsuit against Brian Laundrie, his estate. And I'm sure why not? It's just I just don't know what it matters. Like once the parent Laundries are dismissed, which is inevitable, the estate for Brian Laundrie just confesses judgment because what does it matter? It's like, yeah, you want to sue us for $1 billion? Okay, great. He's got $350 in green stamps or something that you can have because he doesn't have any assets, right? So sure, you can have whatever out of his estate that doesn't exist. So yeah, his estate. What did he have exactly? What does he have? He doesn't have anything, right? He's worth thousands, or maybe 10. Someone said 20,000. He might be worth. He doesn't have anything. So It's just as stupid as everything else. Green stamps, haven't heard about them in a long time. Well, I'm glad I could bring those back. I'm glad I could bring that back for you. Some old school stuff. Oh man. Yeah, good times. All right. Well, yeah, that's the end of this lawsuit. I think when 2 weeks we'll have a decision, I suppose. We're going to go over to Twitch for a while and play some games. So if you would be so kind as to follow this channel over to Twitch, it's twitch.tv/Uncivil Law. We're going to play some Super Mario World for a while and hang out there. So twitch.tv/Uncivil Law. I will join you in about 3 minutes or so. I've been Uncivil Law. Until later, my friends, I hope all is well. Cheers and goodbye. Oh, wait, I do have to do the super chats. That's right, I forgot. Sorry, before I sign off. That is wrong of me. Della said, oh my God, such a great rim motion. Who's this? Don't know. Zipsy said, great. Congrats on the 100K. You're welcome. Israel said, I'm Kurt's raging lack of affirmative duty. Yeah. Criplord said, you see it? We said we assume everything is true, so surely you can't use speculation to refute. Am I missing nuance? We discussed that. It was a great question. Thank you. And then Economath said, somewhat related, grand jury, witness pleads Fifth Amendment. Prosecution grants immunity to compel testimony. Is witness required to accept immunity? Yes. Yes, they're required to accept the immunity. If you in order to have a Fifth Amendment protection, in order for the Fifth Amendment to apply, you have to have legal jeopardy. If legal jeopardy disappears, then you have no Fifth Amendment. That can disappear because statute of limitations or grants of immunity. If they grant you immunity, then yeah, you're forced to testify. The Fifth Amendment no longer applies. So I hope that was helpful. And I do appreciate the question. This will absolutely be dismissed. I'll see you over in about 3 minutes on Twitch. Till later, my friends, I hope all is well. Cheers, my friends, and goodbye. Stephanie says no answering me. Did you have a question, Stephanie? I'm sorry. I didn't see it. I didn't mean to ignore you. Did you have a question? I'm looking. I'm not seeing it. What did I miss? I'm not seeing it. What did I miss? I'm sorry. I'm not seeing what. Did you? I don't see what. I don't understand. Yeah, I've already said I'll do a stream with you tonight. We already discussed that. Yeah, we'll do a stream tonight. We discussed that. We're going to read the gun control. We're going to read the new Gun Control Act case. Yeah, we're going to do a stream tonight. Is that all there was? I left a bunch. Drunk stream after the series court one tonight. Yeah, that's cool. Yeah, all right. Yeah, I'm sorry. I didn't see it before. That's fine. Obviously, that's totally cool. Yeah, for sure. All right, I'll see you guys in a couple minutes over in on Twitch. Twitch.tv/Uncivil Law. I'll see you there in a second. Thanks. Bye.